Hello everyone. So today we are back again with a different topic, that is in constitutional law. So we have discussed few of the topics in constitution, that is salient feature of Indian constitution, making of the Constitution of India, then preamble of the constitution, union and its territory, and also citizenship. Now it's the time to discuss the most important topic of the Constitution of India. The most. Without this topic, our constitution is almost like without a soul. That's why, and I am giving you this heads up because you have to pay attention during the lecture, since this is the most important section or one of the most important sections of the constitution. Now the thing is, as you already know, that how important is part 3 of the Constitution of India, that is fundamental right. At present, fundamental rights are the most significant rights to offer to a citizen. Understood? Now the thing is, we have multiple kinds of right. For example, constitutional right, fundamental right, human right, statutory right, legal right, and more. But the most important one is fundamental right. And important in the sense is that these rights are conferred or promised by the Constitution of India to its citizen for their overall development, for overall justice, that is political and civic justice, and for their development. Okay, and in this sense, this part is very important. We actually cannot live in a democratic country, or in the first place we cannot establish a democratic country without giving fundamental right. Anyways, so you should know that this fundamental right is available to the citizen of a particular country against a state. It is not like my fundamental right can be violated by you. If I am a private individual, you are a private individual, we can't violate each other's fundamental right. Fundamental right is guaranteed by the Constitution to its citizen against a state. State means government, public bodies. Understanding it? So, if a private university, if a shopkeeper, or if any of your friend violates any of the things which is there from section article 14 to article 31, then you cannot take the help of part 3, because these rights are available to us against state. Understanding now? So it is not available against private individual. With this, it is very important to know what is state, because we have this fundamental right. We have bunch of fundamental right divided into 6 categories, and within that we have more fundamental right. And we understand also that we have fundamental right, what all kinds of fundamental right we have. But the most important question is, against whom we can claim the fundamental right. And this is answered in Article 12 of the Constitution of India. So Article 12 of the Constitution of India defines state. What is the state? Because if you will see that Article 14 says that the state shall provide equality of law. है ना? Article 21 is saying that the state shall not take right to life and all. So what is this the state? This term is defined by Article 12 of the Constitution. And what is Article 12? Article 12 says that in this part means part 3. So this definition of the state is specifically designed for part 3, not for the rest of the Constitution. है ना? Then when we will start DPSP, Directive Principle of State Policy, then we will see that there also it is mentioned that whatever definition Article 12 is saying for the context of part 3, the same definition will be applied for context of part 4. है ना? So, but for the rest of the Constitution, we don't go strictly with this definition. This definition is strictly for part 3 of the Constitution of India. And if any part wants to just take this definition, you can mention in your own part. Understanding? So part 3. In this part, unless the context otherwise required, by the time something special is not mentioned, then this will be applicable. So Article 12 says, in this part, unless the context otherwise requires, the state includes. Now, 4 things are there. The state includes the government and Parliament of India, the government and legislature of a state, local authorities and other authorities. These 4 things are there in the definition of a state. So instead of defining what is a state, this definition gives that what state includes. Understanding? Not giving you a proper definition, but only giving you that the definition of a state includes government and Parliament of India, government and legislature of the state, local authorities and other authorities. Understanding? With this, let's talk what is Parliament. So we don't have any debate on this thing. What is Parliament? We know Parliament consists of President, Lok Sabha, Rajya Sabha. Very simple, very clear. And it is the supreme law making authority. Then we know executive. Executive means the that body which implement the law and policies made by the legislature. We all know this. And also this executive includes ministries, ministers and I can say bureaucrats. So these people comes under executive. Then we have government. That is government of central government, and then we have state governments. So we do not have any confusion on the first 2, that is the government and Parliament of India, the government and legislature of the state. On these 2 first things, we don't have any confusion that the state includes this, and we well know what are these things. Some confusion is there for what is local authority, but this confusion was addressed by the Supreme Court in the case of Rashid Ahmad versus Municipal Board, Kerala. Now just giving you heads up, gone are those days when we were discussing preamble or union and territory and citizenship. Those parts were comparatively simpler and little in concept. But this fundamental right is like very, very, very vast. It's like an ocean. So I can literally write a book on Article 12, this much content this Article 12 has. And just don't let me start on Article 21, 19, 14. It's all together like, it's offered in LLM. There's a specialization on these subjects. So obviously in this lecture series of hardly 30 minutes and 35 minutes, I cannot give you the 360 view. But what I will try to at least give you the minimum so that you can build on your concept later. So minimum तो मैं बताऊंगी तुम्हें जितना as a student of law you are required. It is necessary to know. That much I will teach you in this lecture. But my heads up for you people is there is no limit to for these articles. So the more you study, the more you will enjoy and the more you will understand, oh my god, this is the widest interpretation of this section, article. So with this I am just telling you, I will cover the basic concept here and go to the textbook. We have many cases, plethora of cases, uncountable. So you can read and read and read. Here we will discuss the basic concept. So for Article 12, even I thought that I will not discuss much of the articles, case laws here, and I will only stick to the landmark cases. Even then, I have to discuss at least 12 to 13 cases. Even when I tried my best to cut it down to the minimum. Even then I have to discuss around 12 to 13. So if you go to the textbook, you will get 20-25 cases. And out of these, 10 cases are most important. If you are not mentioning those cases, you cannot explain what is Article 12. Because Article 12, the present meaning of Article 12 is actually the development or contribution or interpretation by the Supreme Court of India. है ना? Constitution में तो it's only written that these four things are the state. But who will define what is local authority? Who will define what is other authority? Who will define? The Supreme Court will define. And it is not like the Supreme Court will sit one day and will start defining what is local authority or other authority. No. The Supreme Court, when the case comes, when the respondent and appellant are asking what is this, whether this particular body is a state or not, whether the right which is violated, the fundamental right which is violated by this particular body, will we get some remedy or not? And the moment Supreme Court says that yes, this body is a state, then you can ask for your remedy, that is for the violation of fundamental right. Understanding? That's why it is very important to know what is a state. Then only you can ask for your fundamental right. Then only you can go to the court and bring that body in the court and will say you have violated my fundamental right, you have to pay for this. Right? So first two में तो कोई problem नहीं आया. And this third one, that is what is local authority. In the case of Rashid Ahmed versus Municipal Board, Kirana, Supreme Court defined that the local authority term includes municipalities, panchayat, district board, improvement trust, port trust, mining settlement board, etc. ठीक है? And Supreme Court is saying that even all panchayats, municipalities, cooperative societies mentioned in Part 9, 9A, 9B of the Constitution will be included in this category. So, for local authorities, we had no much of that problem. And also, in a subsequent case, in the following cases, the Supreme Court said that local authorities means all the local self-government who has the power to make laws and is considered as instrumentality of the state. So they have, these local authorities must have power to make laws and they are instrumentality of the state. Okay. So this is the local authority. Now the major debatable or major term which usually comes before the court is to interpret other authority. What is this other authority? Now, Supreme Court started to address this question since the year 1954. And for the first time, a case came to the Supreme Court where the Supreme Court was asked to decide the nature of a particular body, whether it is a state or not. And from that point, this journey starts. And now we have many bodies which come under the term state, although it is not specifically mentioned in the Article 12, but through Supreme Court judgments, we consider those bodies as the state. And so let's start the journey of the Supreme Court of India on this point. ठीक है? कैसे state का interpretation, the interpretation of the word state has become broadened. Now the first case law is, you have to write many case laws, na? Minimum 10 to 12, so be ready. The first case law is University of Madras versus Shantabai, year is 1954. University of Madras versus Shantabai, year is 1954. What happened in this case? So in this case, actually the party was asking, or the party was questioning, what is the nature of University of Madras? Is it a state or is it not a state? Now what happened in this case? I am just telling you the fact of the case. That is, a new college named Mahatma Gandhi Memorial College was established in the town of Udupi UDP, UDIPI. It's in Tamil Nadu. Okay. So a new college, Mahatma Gandhi Memorial College, was established in the year 1929 in the town of Udupi. So while granting affiliation to this college, permission was granted by the syndicate that in the first year of this college you can give admission to 10 girls, and then this college will not take girl students. It will be purely boys college, but for the first year you can give admission for 10 of the girl student. Understood? And then no women students will be admitted without special sanction of the syndicate. So for the first year this permission was granted, and said that from the next year, from the following years, special permission is required for the admission of any girl student. In this case, the appellant Shantabai, girl student. What happened? In this case, the appellant Shantabai applied for the admission of for this college, and her admission was denied. Why denied? On the ground of sex. That is, she is a girl. We cannot give admission to her. So Shantabai went to the Supreme Court and asked the Supreme Court to give me remedy for the violation of my fundamental right. Now the Supreme Court has to decide whether the University of Madras is a state or not, because a fundamental right is only applicable when it is violated by the state, not by the private body. So firstly, Supreme Court decided that whether University of Madras is a state or not, and unfortunately it was decided in this case that University of Madras is not a state and your fundamental right is not violated. And this was very unfortunate, but fortunately after these cases, all the cases have liberal interpretation of Article 12 and the word state. This is the only case which followed this conservative approach in defining what is a state. After this, all the cases were like they are opening doors after doors to just broaden the ambit of this word state, so that more people may get the fundamental right, or against most of the bodies the fundamental rights can be asked. So the fundamental right jurisprudence in that way got very broadened, and this is the only case where Supreme Court followed very conservative interpretation and said University of Madras is not a state. है ना? तो क्या हुआ? Finally, Supreme Court is saying University of Madras is not a state within the meaning of Article 12 of the Constitution, and its regulations are not in violation of Article 15(1), that is discrimination on the ground of sex, because it's not a state, it can do anything. So this was the case of Shantabai versus State of Madras, and in this case the Supreme Court followed the rule of adjustum generis. We should know now what's the reason that Supreme Court held that the University of Madras is not the state. The reason is, the Supreme Court said, the reason is the principle of adjustum generis. And what does mean? It means that all things of like nature are included in that thing. All things of like nature are included in that thing, and this also means that bodies exercising governmental or sovereign function would only be covered under the meaning other authorities. So Supreme Court is saying, by applying the principle of adjustum generis, which says that things of like nature. And what Supreme Court is saying? That in Article 12 we have government, parliament, government of a state, legislature of a state, then local authorities. So something of like nature which has this governmental and sovereign function should be included, and not other things. And this was the reason behind it. That's why University of Madras, according to Supreme Court of that time, is not a state. But thankfully, after this we have a very good judgment And the next case law is Srimati Ujjambai versus State of UP. The year is 1962. This is the second case law. Third. One was in local authority and then we started other authority, and this is the second case under other authority. है ना? Now this is Srimati Ujjambai versus State of 1962. In this case, Supreme Court rejected the principle of adjustum generis. Very good. And it interpreted the word state with liberal interpretation. So the court observed, to apply the adjustum generis rule, there should be a different category to the heads running through the body already specific. है ना? In Article 12, the bodies have no common genus. They all are a bit different. Adjustum generis can be applied only when there is some different category of head running through the already specific existing bodies. है ना? So there should be something common. But Article 12, the bodies have no common genus. So how come you can apply the principle of adjustum generis? And court rejected this application of the rule. Then we have another case law that is Rajasthan Electricity Board versus Mohanlal. One thing I am mentioning, all the cases are landmark, are important. You cannot explain this topic, you cannot define what is a state unless you take help of these cases. So don't skip any of the case, because slowly, gradually you will see that how the state's meaning is getting wider and wider. And this is again very prominent case, that is Rajasthan Electricity Board versus Mohanlal. The year is 1967. What happened in this case? In this case, the Supreme Court said that the other authority under Article 12 include all authorities created by the Constitution and any statute empowered by law. Very simple thing. What Supreme Court is saying? That any body which is created, which is established either by the Constitution itself or by any statute. What is statute? You already know as a law student. A statute, act or legislation which is passed by the parliament or state legislature. So the Supreme Court is saying any body, if that is established or created by any act of a legislature or parliament, that body is the state. है ना? So, and then Supreme Court is also saying that statutory authority does not need to be engaged in performing government or sovereign function. University of Madras में बोला गया था, University of Madras versus शांताबाई, that body should perform sovereign or state function. नहीं, ऐसा नहीं करना है. इसने बोला राजस्थान इलेक्ट्रिसिटी बोर्ड में, Supreme Court is saying that statutory body which has been established out of a particular act passed by state legislature or parliament does not need to engage in performing governmental or sovereign function. No. The court observed that the Rajasthan Electricity Board in this case had the power to give directions, and if people are disobeying these directions, then this body has also power to punish them. मत भरो electricity bill. Those officers will come and cut your connection. So firstly you have to follow the direction of this body, and then this body has the power to give you punishment also. So this is one of the function, even though not at par with the government or sovereign function, but it's like one of the function of the government, na? So it's not like parliament can do everything. It has to create bodies to take care of a particular thing. And if that body has the power to create direction, to frame direction, to order, and also to punish, that is the state, according to the Supreme Court of India. है ना? So this case overruled the judgment given in the University of Madras versus Shanta Bai, which excludes university from the definition of the state. है ना? तो this case again a very good case. Then we have fourth case law, that is Sukhdev Singh versus Bhagat Ram, and then we have fifth case law, Sabhajit Tiwari versus Union of India. Why I am telling you these both cases together? Because these both cases were decided on the same date, same year by the same bench, and still you will see that in one case few bodies were said the state and other few bodies were said not a state. Because this time the Supreme Court has a definite principle, and applying that, some people will pass the test of the state, some bodies will fail the test of the state. So Supreme Court has principle, and we will discuss these two case laws, Sukhdev Singh versus Bhagat Ram 1975, Sabhajit Tiwari versus Union of India 1975, same date, same bench, different judgment. So this will be continued in our next lecture. Thank you.